Telecommunication Bill. As I mentioned earlier, we would be live streaming and recording this session. So Department of Telecommunication has released a draft, the Indian Telecommunication Bill 2022 for public consultation, and the last date to submit comments is 20th October. So we from CCAOI thought it is important that the community gets a better understanding of this proposed bill and the aspects which needs to be refined or which may be of concern for certain stakeholders, and also encourage everyone to make their submissions before the deadline. From CCAOI, we always are endeavoring to build the capacity within the community on digital policy issues, encouraging stakeholders to actually participate in public policy discussions, and also providing more nuanced understanding from experts on these issues, and ultimately trying to articulate the concerns of internet users and non-users before the decision makers. So today we have a very eclectic panel of distinguished speakers who would be providing their perspectives on this bill. We have Akshi, Rastogi from Shardul, Amarchand, Mangaldas, who would be providing a high-level overview of this bill. And we have experts like Neha Choudhary from Ikigai Law, Uttara Ganesh from Snapchat, Amit Mathur from Reliance Jio Infocomm, Dr. Mahesh Uppal, Rajesh Chharia from the Internet Service Providers Association of India, Kazim Rizvi from the Dialogue, and Nikhil Pahwa from MediaNama. So with me, I have Ahita and Shraddhanjali from Youth India IGF, who would be moderating the chat. And we have a few Youth India IGF Fellows of 2022 who would be rapporteuring for this session. We want this session to be interactive, and we want you to share your views, thoughts in the chat. In case you have any question, you can put it in the chat with a prefix question. And if there is a comment, you could put it with a prefix as comment. And during the question answer session, we'll try to take in as many questions as possible. You can also raise your hand and we will ask you to speak. But when you speak, please remember to mention your name and affiliation. And lastly, while we encourage you to participate and share your views, we want you to be respectful and courteous to each other, even if we have divergent views. No abusive language, personal attacks would be tolerated in the platform. And with this, I would now like to invite Akshi to start her presentation. Akshi, if you are there, and Shubhrajit, can you make Akshi a co-host, please? Because she would be sharing her screen.
Thanks, Amrita.
Sure.
Yeah. Just a moment, Akshi.
Yeah.
Actually, you can share now your screen.
Just one quick. Hi everyone, this is Akshi from Shardul Amarchand, and I will be giving a quick overview of the draft bill 2022 today. I want to keep it really short and as free as possible of lawyer speak. Sorry, am I audible, Amrita?
Yes, you are.
Yeah, okay, thank you. So to go ahead, as we all know, in July 2020, the DoT had published a consultation paper on the need for a new legal framework governing telecommunication in India. Following stakeholder comments to that consultation paper, in September, the DoT has now released a draft bill, which is publicly available for comments again from stakeholders, the last date of which is 20th of October. The need for the new bill, as recognized under the explanatory memo, which has been released along with the draft bill, is, of course, that currently we have a really outdated legal framework governing the telecommunication sector. And this bill is the government's initiative to restructure the legal and the regulatory framework for the telecommunication sector, attuned to today's realities and changing technology. Again, once enacted, the draft bill will replace 3 legislations, which include the Indian Telegraph Act, the Wireless Telegraphy Act, and the Telegraph Wires Unlawful Possessions Act. The bill also does amend the TRAI Act as well. Moving to the overview, the first and one of the biggest changes that happened through the bill is that the concept of telegraph itself has been replaced by the term telecommunication, which is a really broad definition, which includes, transmission or reception of any messages through all sorts of means, including via radio or other electromagnetic systems. Now, telecommunication services, the definition itself has been expanded to include several new categories of services in the scope of telecommunication services itself. Some of these include internet-based communication services, interpersonal communication services, and over-the-top or OTT communication services. Interestingly, none of these terms themselves find any definition within the bill itself. So, for instance, while over-the-top communication services could include services like Signal, which provide, calling or chatting features, but technically speaking, they may or may not extend to also, let's say, something like a gaming service or a multi-gaming app, which allows users to talk during the gaming chat and communicate with each other. Whether that is included in OTT communication services, again, the term is not being defined in the bill itself. Moving on, Section 3 recognizes the government's power to grant 4 sorts of permission. 1, licenses for providing telecommunication services and establishing and maintaining a telecom network. 2, registrations for telecom infrastructure, which are listed out in Schedule 5. Authorizations for possessing wireless equipment, and of course, assignment of spectrum. Now, the government will, of course, prescribe the manner in which all of these permissions will be granted, including any terms and conditions to which, let's say, a license will be subject to. Interestingly, what's also been provided, and I think a good thing for the industry, what's also been provided, the bill recognizes that existing licensees prior to a specific appointed date under the bill can continue to provide their services under existing terms and conditions or migrate to the new terms and conditions that will be prescribed by the government. A provision on similar lines does exist for registrations as well, where the existing registrants can continue under the same registration or migrate to the new one, but continue under their older ones only for a period of 5 years, for instance. Moving to the licensing related provisions. Now, as I said, the term telecom services itself has been expanded to include several new categories of service providers. Each of those service providers will now require a license to provide their services. The terms and conditions is, again, something that the government will have to prescribe. What it does recognize through the bill that there is going to be no retrospective modifications of the new license terms and conditions to the detriment of the licensee, except for a few specific cases in which the government does have broad and expanded rights and powers in situations such as, let's say, public emergency or public safety and war. The bill also has some very new provisions, provides for new provisions, including, for instance, that licensees now will be required to identify their users for a prescribed verifiable mode of identification. Again, the mode of identification is something that the government will prescribe, but licensees will be required to ensure that they enable their services to identify their users through this verifiable mode. And this identity will, of course, we have to be shown to the recipient of a message, the term message itself being broadly defined. So the sender's identity will have to necessarily be shown to the recipient itself. The intent of the government behind introducing this provision, as per the explanatory memo, is to prevent cyber frauds. As I said, the government is also looking to prescribe terms and conditions. Similar to that, for any breach of the terms and condition, the bill does have provisions detailing out what will be the consequences of that breach. This could include, let's say, a monetary penalty a direction to do a certain act or to stop doing a certain act so that the breach can be prevented, or also a suspension, revocation, or varying the license or the registration or the authorization, as the case may be. Now, what's interesting is that the penalty that can be imposed for a breach of terms and conditions will, of course, now be imposed based on severity, which has been recognized, which the severity has been set out in another schedule of the bill itself. For instance, a very severe breach can result into a monetary penalty of 5 crores, whereas a minor breach can result into a penalty of 1 lakh. The provision also sets out several factors that the government will have to consider before taking any action against the breach itself, which includes, let's say, the intention or the negligence on part of the licensee, the nature and the gravity of the breach, or the revenue loss that the government also has suffered. Any person who's aggrieved of any action by the government under this provision, for instance, can prefer an appeal, but the appellate authority itself is also to be prescribed. So this is, I think, the most important set of points on licensing and related to licensing. For spectrum, similarly, the primary method that the bill recognizes is of course auction, allocation through an auction. Whereas administrative allocation instances have been recognized under Schedule 1. Most of these relate to some functions of the government or other entries which are more in public interest. For example, let's say space research and application or defense or transportation, etc. Existing allocations, of course, which have been made through auctions, will continue for the period of for the duration of that allocation. The government has also introduced several new provisions to allow for more efficient utilization of the spectrum, as the explanatory note puts it, which include, let's say, harmonizing, which is rearranging a frequency, or refarming, that is allowing new uses of the spectrum, deploying new technology, or even doing a secondary assignment of the existing spectrum on a non-interference basis. The government also has a power to terminate the assignment to the existing assignees if the spectrum has been unutilized. Of course, this will be only done after providing these assignees some reasonable opportunity of being heard. Coming to the provisions on right-of-way, now these right-of-way in replacing the 2016 right-of-way rules, now they're being codified in a principal legislation. The bill, of course, provides just a broad framework for right-of-way in both public and private properties. An interesting point being that for applications or establishing right-of-way on public properties can only be rejected on substantive grounds. Again, as with a lot of parts of this bill, the specific procedure, including the timelines for approval or the appropriate authority for dispute resolution, etc., will, of course, be prescribed by the government in due time. Moving on to provisions for mergers and insolvencies, the process has been simplified. Any merger, demerger, or a restructuring proceeding can be done based on whatever requirements are there under the relevant law with a notice to the central government. The resultant entity, of course, will have to comply with all the terms and conditions, with the terms and conditions that were applicable to the previous one as well. For insolvency, if there's any sort of, let's say, a licensing entity or an assignee of the spectrum which is undergoing insolvency proceedings, the bill does recognize that they can continue to operate as a going concern, provided they fulfill 3 conditions. First, being that they can continue to provide the telecom service or utilize that spectrum, let's say. 2, they do not default on any of their payments. And 3, that they comply with any additional or any modified prescribed terms and conditions that the government may additionally prescribe to them. If these conditions, let's say, cannot be complied with, the assigned spectrum, in the case of an assignee, will revert back to the government. Coming to, I think, what is one of the most debated set of provisions under the draft bill are the sections relating to government powers in cases of public safety, public emergency, or certain other very specific national level events. Now, in the event of a public emergency or in the interest of public safety, the central government and the state government has the power to take 1, temporary possession of telecom services network or infrastructure, demand a priority call routing scheme, or also to direct suspension of transmission of messages, detain them, intercept those messages, or even ask for disclosure of those messages. This also extends to suspending suspending communication from the telecom network altogether. That is, also direct internet shutdowns. Now, what's interesting to see here is that the terms public safety and public emergency themselves don't find any definition under the terms. Though, of course, the bill does recognize that, these measures can only be taken for a specific period till the time the situation for a public emergency or a public safety does exist. The government also, under one of these provisions, does have power to issue directions through a notification on applicable standards of procurement of telecom equipment, etc. in again recognized situations like national security, relations with foreign states, or war. So this is an expanded set of rights that have been provided to the government in certain cases. The bill also recognizes the central government's ability to provide for measures for protection of users against promotional and advertising messages. These measures could include, let's say, mandating obtaining of prior consent before receiving such messages, or maintaining a do not disturb registry, or even establishing a reporting mechanism for such users. The government also has the ability under the bill or in the power to prescribe standards, among other things, for, let's say, telecom equipment, manufacturers, importers, or in the provision of the telecom service, on the reliability of the provision of telecom services to the public as well. The bill does recognize the government's power, or enables the government to actually create a regulatory sandbox, which will allow live testing in a more controlled and supervised environment. This is, of course, subject to a more flexible framework being prescribed by the government, where the government can, let's say, provide certain exemptions or exceptions to the more stricter conditions of a license or an authorization. The bill also looks to amend the Triad, while some of these amendments are, of course, cosmetic in order to reflect the change in the terminology which the bill has brought forth. Several of the provisions are actually quite interesting, which in particular, one which repeals the provision requiring the central government to consult CCAOI on the need and timing of introducing new service providers, or one of the provisions which which direct them to refer back CCAOI's recommendations, to which the central government has disagreed with. The bill is looking to repeal both of these provisions. And the final section, which I'd like to touch upon for the overview of the bill, is with respect to the offences, penalties, and compounding. Schedule 3 provides the punishment for the offences that have been recognized under the bill. It also clarifies whether each of these are cognizable or compoundable. Offences include, for instance, something like providing a telecom service without a license, or negligently causing damage to telecom infrastructure. These offences are punishable with fine, imprisonment, suspension of the telecom itself, suspension of the telecom service or the infrastructure itself, or a combination of any of these, which again are listed down out all in Schedule 3. The bill also recognizes that any employee responsible for the conduct of the business of the company, which has committed the offence, will be liable, of course, excluding independent directors. The bill also provides a broad framework for compounding settlement, which is basically settlement instead of criminal proceedings being initiated against you. The sum and procedure, of course, can be prescribed by the central government further. Finally, so this was a brief overview of the provisions of the bill itself. As we all know, the DOT has invited comments from stakeholders on the draft bill till the 20th of October. The Minister of Communications himself has made certain statements indicating that the government is looking to enact the bill in the next few months or during the next 6 to 10 months of a period, and that this is just the first step in reforming the telecom sector, and that the government is looking to come out with the second set of reforms as well to simplify the licensing regime itself. But that's, of course, for after once the bill has been finalized and enacted completely. So I hope that the overview was helpful and simple enough.
Thanks, Akshi. Thanks for simplifying it and sharing it within 6 to 7 minutes, though it's a huge thing. So may I now move on to Neha. Neha, you work with Ikigai Law and you have been consulting a lot of organizations on this matter and have been looking at the telecom draft. Can you share your thoughts on this, and especially the concerning areas, and what ideally a telecom bill should look like?
Yeah, thanks so much, Amrita, for having me. It's really excited and really looking forward to the next hour or so. I think it should be a fascinating and interesting discussion. So thanks very much for having me here. Like you said, I work with Ikigai Law. I'm a lawyer by training, and we've been, for the past few weeks, we've been spending a fair bit of time and many sleepless nights looking at different aspects of this bill. I'll talk about, and I do think that there is really a lot to unpack in this draft, but I think for the next 5 minutes, I'd like to focus on one theme that I think cuts through very many different aspects of the bill, whether it's definitions, whether it's licenses, exceptions, or even spectrum. There's a lot that we found when we were analyzing the bill, that there's a lot that it leaves open to central government discretion. And I think that this is a recurring theme that we find coming through several different aspects. And one of the areas that we actually thought was perhaps most concerning, and in terms of recommendations, we were then thinking through what are the kind of guardrails and fetters or safeguards that we'd like to have built into the legislation and the very text of the bill itself, to make sure that we end up with a comprehensive legislation that's also ensuring regulatory certainty for the various stakeholders that it's seeking to govern and legislate, right? And I think a related question also is what kind of regulatory burdens I think we're looking to enforce on the various different actors that will definitely be affected, and a wider pool of actors now that will be affected by the bill, right? Going back to the point that Akshi was making earlier as well, one of the main things that the bill has done is we have a fairly wide definition of what constitutes a telecommunication service, especially when you read it together with all of the other definitions that it does relate back to. Now, what we've seen in terms of the consultation paper that the DOT did release accompanying the bill, they talk about one of the key objectives being a simplification of the regulatory framework governing telecommunication in the country. But if you actually read the letter of the law, the text of the bill that accompanies this consultation paper, that's where we felt that there was a little bit of a mismatch. I don't necessarily think that we're going to see a simplified legislative framework if this is the text of the bill that we end up with. We don't really see too many material changes. We do see a few, but we don't see too many material changes in terms of how our telecom law is today, with what will happen when the bill comes into force. And we also, the point that I was making earlier, right? Lots of room for central government discretion, lots of room for a lot of it is left open to the government to make a decision on, which is neither a simplification of the regulatory framework, nor does it lead us to an end goal where you're thinking in terms of regulatory certainty, right? One example, of course, the definition of telecom services, fairly wide, all-encompassing definition. And I don't want to get into, personally, I think it's too wide. I do think that there needs to be a distinction between, folks who are providing or operating the network, folks who are governing the network layer, as well as folks who are operating using the network layer and providing services that operate on top of the network layer. But that aside, even here, this is another example where you do see room left open for the central government to identify additional categories or additional kinds of services as telecom services. What we'd love to see is there be a much more sort of a much more clear idea of what constitutes telecom services baked into the law as well. That's one. Second, recognizing that a sovereign government or a state will want to keep itself, will want to have powers of discretion for itself. What are the kinds of safeguards that we can build in here such that we will have the kind of certainty that we're looking for, right? Identifying very specific principles on the basis of which then you ascertain whether or not something is a telecom service or not. Am I enabling the provision of certain kinds of services? Mandating, say, interministerial consultations, because what you're going to end up with otherwise, particularly say on OTT platforms and the like, you're going to have 3 different ministries otherwise looking at potentially regulating the same sphere. Specifically on OTT, you have MeitY that's already looking at it. You've got Reforms, Digital India Act, so on and so forth in the works. You have MIB, which takes a claim to this space as well. And now you have the DOT sort of getting in on the action. So there is a fair bit of regulatory overlap. So definitely interministerial consultations, lots and lots of stakeholder consultations, regulatory impact assessments, not something that we see done very often or at all when we're looking at formulating new laws and policies in the country. I think CUTS did a study on this not very long ago. So particularly on ring fencing, perhaps on defining telecommunication services and ring fencing central government powers, this is one thing that we'd like to see. Second area where we do notice a fair bit of discretion again, I think, is the administrative assignment of spectrum. I think good positive move, but again, it's sort of, the bill just opens the door, I think, to that and says that this is a possibility, although spectrum is still the preferred mode of auction is still the preferred mode of assigning spectrum. We are opening the door to assignments, administrative assignments. And I think that, again, having a lot more certainty on this would be helpful. And the third area where we see a lot of central government or the potential for central government discretion coming in is what we're reading to be a reading down or a curtailment in some ways of the role of the TRAI, which is a statutory regulator, right? So right now, according to the law, there are certain areas on which, not all areas, but there are certain areas on which the TOT needs to consult with the TRAI, and there is a back and forth, right? The TRAI can sort of disagree with the DOT, make its recommendations to the DOT. The DOT can then, ultimately the final call is still with the DOT. The DOT can send back to the TRAI if it disagrees with the TRAI's recommendation and say, please reconsider, so on and so forth. But even by law, the TRAI is required to do a fairly sort of rigorous consultation process. And we do see that. It's one of the, I honestly think out of all of the regulators, it's one of the most sort of consultative ones, right? You've got a call for comments, you get to respond, you get to have counter comments, there is an open house discussion. And I think that all things considered, it is a fairly robust and transparent process that the TRAI follows. And I think in the new bill, we're seeing some of this role getting diluted. It's entirely possible that the TOT might also adopt a similarly consultative framework, but I do think that there is merit in having a separate statutory regulator that's looking at telecom law and telecom policy issues in a rigorous and consultative manner. And this is another area that we find where we're now seeing a little bit of a move towards much more central government discretion. So I think that would be, I think, my overarching theme for opening remarks, right? We see, and there are many other areas, quite frankly, where we see this, even in dispute resolution, arbitration, what goes to arbitration when, what is the process to be followed, so on and so forth. So several areas. And I think that this is an area that personally we're looking at fairly closely, and would love to hear what everyone else thinks as well. I'll pause with that, Amrita.
Thanks, Neha. We'll bring you back later. I think we'll have more points coming in. So I will now bring in Uttara, who actually represents the so-called OTTs. Uttara, we would like to hear your initial comments on the draft.
Thank you. Thank you so much, Amrita. Hi, everyone. Always fun to gather to discuss our policy woes as an ecosystem. And luckily or not so luckily, this is a bit of an all-weather thing at this point. Akshi, thanks so much for that comprehensive overview. I thought it was a very effective summary of that of the law. I had a couple of things to say today. Some are sort of meta and some are more specific comments pertaining to the draft bill itself. So when my colleagues and I discussed the bill internally earlier this week, right, one of the main questions that was raised was, why did this draft even come to be, and what specific problem is it trying to solve? And on this fundamental question of legislative intent, right, I have to say I am aligned with the DOT. It's clear to me that a bill that was architected in the 1800s deserves a relook. Now, I'm not super close to telco licensing related issues, but in the many years that we have had this debate about regulatory arbitrage, right, or same service, same rules, what has struck me is that, even as I'm arguing from the OTT side, is that life is kind of hard for telcos, right? The licensing regime seems checkered and convoluted from where I stand, and issues such as securing right of way from local authorities and all the other several obligations and responsibilities that they have to carry out, all of that seems straight up hellish, if I'm honest. And I guess given that the entirety of the potential $1 trillion economy of digital India sits on top of telco infrastructure, right, it makes sense to me that we might want to do over the regulatory framework. So it definitely sounds like an opportunity for us to make this regime nimble, future-proof, and sort of ready for the next wave of sort of technological advancements, right? But that being said, whether this specific draft aligned with that intent, I'm not so sure. I think a key thing worth understanding a bit better is, and maybe Dr. Uppal and Nikhil or others close to telco experience could help us understand this a bit better, is whether there has been any extent of licensing reform at all within the bill, right? Neha, you made some excellent points about spectrum assignment and regulatory overlap, etc. So I won't get into that. But specifically from the perspective of Snap, a service layer company that offers messaging services, this bill certainly seems more problematic than reformative, right? And I say this because the basic principle of separating the infrastructure or the service layer and the service layer, or the content and carriage layers have, from a regulatory standpoint, has been sort of diluted, right? And again, to Neha's point as well, it's because the definition of telecommunication services is super widely cast, right? It includes OTT communication services as well as internet-based communication services. And this means that basically all service layer companies now have to acquire a license to operate. And they're also sort of subject to a whole host of other conditions, including like interception, contributing to the rebranded version of the USO fund. They're all pretty problematic, right? And I guess just stepping back for a second as well, right? The damage that this does is much more than I think the DOT perhaps acknowledges at the moment or recognizes. A lot of the current excitement around IT today in India, to my mind, is owed to the OTT segment, right? There's infinitely more innovation happening in the content layer than in the telco layer, right? But I saw this article that which told there are 75,000 startups in India today, and I reckon many of them are service layer companies that would fall under this bill's definition of telecommunication services. Right. And if you just think about it, in the last 3 years alone, I think from 2019 to now, we went from having 11 unicorns to like 107 or something this year. Right. So in a sense, what we're doing is that we're creating a licensing framework for a lot of companies, and they're sort of limiting their ability to change product, move quickly, and innovate. Right. Which is much more damage than we're able to acknowledge, or the bill sort of is able to acknowledge. So and the reason that they're able to do this is because of the current regime, right? The IT Act is fairly light touch. It allows for companies to be as nimble as possible. So having said all that, I guess from a Snap perspective, our main recommendation for all these reasons is that if the law actually wants to achieve what it says it wants to, my strong recommendation is that we drop the words OTT communication service and internet-based communication service from the definition of telecom services, right? And I guess instead of us, like the DOT, taking the sort of contrarian approach where we're basically the only country in the world trying to regulate service layer companies and sort of just simply like increasing government remit, right? Maybe we should spend a bit more time reforming the licensing regime, right, in a meaningful sort of way. And maybe that is much more helpful for the ecosystem, especially, right, as we sort of are coming upon this vertical integration type situation today where many telcos actually are also offering content and carriage services. So I'll stop there, but hopefully that provides you an overview of where Snap's coming from while engaging on this discussion.
Right. Thanks, Uttara. Now I'll bring in Amit here. Amit, you are in a pretty interesting spot. You represent a Geo, which is perhaps the largest, nearly the largest telco today. And you also have services, internet services from Geo coming up. So how does Geo look at this particular bill? What are the places where you think there should be some reforms?
Thanks, Amrita, for this opportunity to just present our views. We've looked at the bill, and if you look at the intent has been there. When we look at the consultation paper which came out, the intent was very clear to simplify the whole process. But somehow there are certain things when we look at the bill itself, there are some concern areas which we also feel that there are there, which needs to be addressed. Some of the points which Akshi and Neha and Uttara also talked about. One is the definition itself. But I have a slightly different view. If you look at what was the definition today in the Telegraph Act, it was much wider. Today, what DOT is trying to do is trying to streamline it, limit it, because the earlier definition of telegraph was all-encompassing. Yes, there are areas where more clarity is required. If you look at OTT communication services, all of us are not very clear of what exactly we are talking about. There are various definitions. TRI has used one definition for OTT communication services. There was a DOT internal committee which looked at net neutrality. They've talked about a slightly different definition of OTT communication services. So clarity on those definitions would go a long way in clearing out some of those concerns which people have today. Like I was in another discussion, there was a discussion whether some of those video on demand kind of services are included in this or not. So those are concern areas which definitely need to be addressed. One important point I would like to raise is that we are missing out a point here when we are talking about telecom bill itself. If you look at it, we are moving towards convergence, and we can wish away whatever is there, but the convergence is happening, even if we don't like it, but it is happening. The end user is using all these services on a single device today, and it's a converged environment for him. If you try to regulate separately, again, we are going into vertical regulations. We'll have all those kinds of issues which Uttara talked about, that one service could be regulated by maybe 3 different entities. So that's something which we feel that this could be an opportunity where we could look at convergence and try and build a framework for convergence itself, and then maybe have separate entities handling different areas. So that's a broader thought which I wanted to talk about. There are concern areas in this itself, in the bill itself, where we talk about, like Uttara touched upon, that the USOF fund. Now, if you look at it, there is so much money which has been collected from telcos. There are some 65,000 crores which has been collected, which went into the consolidated fund and never came to the USOF for deployment. So as telcos, we are saying that, look, first let's utilize that fund before we start collecting more money, because that itself will ensure that the 5% which we are paying as telcos, we can pass it on to the customer. The services cost will go down and the subscriber will gain out of it. Another aspect which we want to look at as USOF is that today we are talking about 5G rollout, but then what are the devices available to the end user? Can we get a device less than 10,000? I don't think so. Even the simplest of 5G device will cost more than 10,000, which a common man will not be able to afford. So maybe this is the right time to utilize that fund which is available to make the device or provide subsidy on the device itself. So that could be another thing which you'd like to look at. Then when we look at, there are certain security aspects which the bill talks about. all of us would agree that the national security is of utmost importance. We have to ensure that, and the individual security is also important. But there is one aspect in the security aspect which they've talked about, is that that everybody has to be verified using a verifiable document. Now, even today in India, we don't have 100% availability of Aadhaar card with everybody. Now, there are people who have a different set of cards, and there is already some 13, 14 defined documents which are accepted by DOT for verification. Now, just moving it to a verifiable document will deprive certain set of people from getting onto the telecom services itself. Plus, there is a cost associated with it. For each of the verifiable, if I have to go back and verify, say, from a passport, then I have to build that infrastructure, connect to them, and that's a cost which comes into that. So this is some aspect which we would like to raise it. Then, it's rightly pointed out by Neha is on the TRI Act. Now, the way TRI is an expert body, and the structure with TRI, DOT, and TDSAT has been working very well for the sector. Because today, if I have a problem against the licensor, I can go to TDSAT. Now, in this, the way it is being looked at, I'm not sure whether TDSAT will still exist or not. That's something which is not very clear. Doing away with some of those functions or the way TRI and DOT interact, like in terms of that, when they send a recommendation, if DOT does not accept it, it can reject it. Today, it has to go back to TRI, ask that, look, you review it, and after review it again comes back. So those checks and balances which are there, we should not disturb it. It's been working well. We don't feel that there is a need to tinker around with that. Another point which is on the spectrum. We feel that spectrum, the only way spectrum allocation should be done is auction, because that gets you the optimal value and there's no subjectivity in that, and we don't want a repeat of 2G scam. Also, it will ensure that there has to be a level playing field when we are talking about commercial services being offered or commercial intent of usage of that spectrum. So anybody who wants for that kind of application, take it through the auction, because it talks about certain things like a state government or central government agency can also be assigned spectrum administrative. Now, government may decide to assign to, say, the state road transport spectrum for their purposes. Now, that is again a commercial use which is happening. So those are issues where we feel that auction should be the only way whenever we are talking about a commercial usage of it. There have been good things about ROW. There is a lot of work which government has done. There are a lot of good things which have come in. There is one suggestion which we talk about, that today we're talking about the common duct and the cable corridors in the buildings. We are saying that it should also include buildings as well as residential areas, because today we are finding that even though we are trying to improve the internet penetration, getting into the building and wiring up the building and making it available to individual users into that building is becoming a major bottleneck. A common duct would solve a lot of problems with that. But there is another word of caution which I like to bring it here in terms of the ROW. Even though it says that whatever the central government decides would be would override what the state looks at it, or the local authorities. But the Constitution in India defines certain powers which reside with the local authorities in terms of providing permissions in the local areas. How is that going to play out? We are not very sure. So what we are suggesting is that there has to be more coordination between the center, the state, and the local authorities to ensure ROW is available. Because otherwise, whatever we are talking about, 5G or FTTH, is not going to happen unless we have this issue sorted out and have a very smooth mechanism for it. One interesting thing which is put into this is, which Akshi has also pointed out, is the sandbox concept. It could be a very useful tool to bring in more and more services into it. So these are major points which I thought I'll just bring across.
Thanks, Amit.
From
We
the
will
telco's perspective.
you come back later when we have other comments coming in. There is a question for you in the chat. In case you want, you can type it in the chat, or we'll take it later. I think Rajesh is in a poor connectivity area, so I would now like to bring in Dr. Uppal. So you've been looking at the telecom industry in India since the inception. And even our TRAI, etc. How do you look at this bill? Dr. Uppal, you would have to unmute yourself. I can't remember.
Thank you, Amrita. I was wondering whether you wanted to say that I came from the time when the original act was passed.
Not at all.
But so be it. I'm almost there. Okay. The act itself, the Telegraph Act that we are trying to replace, the one that was passed in 1885, had, first thing we need to worry about is what exactly was wrong with it and what we needed changed in that. And when you look at that, you discover that actually the act really did not come in the way of a whole host of very, very transformational changes that have already taken place in the last 30-odd years. And whether it was the removal of the government monopoly, whether it was the entry of private players, whether it was the creation of the TRAI, whether it was the move from license fees to revenue sharing, whether it was even the transfer, the conversion of Vodafone's debt into equity. None of those things really were hindered by the act. So the question really arises, what exactly is the problem with the act? And I believe there are 2 or 3 problems with the act. Because of its colonial heritage, it has a very strong command and control sense to it. And the other thing is that it came at a time when voice telephony was de facto the only service, and a monopoly provider, usually a government, was the only service provider. So what the act understandably didn't have is any serious provision for multiple players, for competition between players, competition between technologies, competition between business models, and so on and so forth. What it lacked was any kind of support for a competitive telecom sector. And so one key gap that the new bill should, in fact, try and address is reduce government control and to provide much more incentives for competition in the market, whether it is between players, technologies, or business models. And as Neha and Uttara and others have pointed out, this is where the new bill falls desperately short. That's one. The second thing is that the bill has a definition of telecom service. And I think here I would just sort of try and address the point that Amit made, that somehow the old definition was much wider. The definition of, it's not the definition of telecommunications which is an issue, it's the definition of a telecom service that is at the root of our problems. And yes, the definition of telecommunications itself is as wide as it comes. Pretty much any movement of bytes, bits and bytes, is telecommunication by that definition. But, just like transport is simply a movement of things, doesn't mean that that is something relevant for regulatory purposes. It's in fact, it's absolutely trivial for regulatory purposes because it ignores markets, ignores players, ignores market sizes, all kinds of things that regulators and policymakers concern themselves with. So this whole idea that this converged definition of telecommunications somehow makes this bill very sound, I think is very, very problematic. In fact, no legislation that I know of has any of these kinds of issues. So there is that. And I think the confusion that the bill has now created between different layers of the telecom networks has become quite a problem. Earlier, what we were dealing with is players who were active in the PSTN, the public switch telecom network, whether it was the fixed and mobile players, whether it was ISPs, whether it was long distance players, NLD, and right? Now we have moved on to the layer above. And the layer above is extremely complicated, including for actual so-called OTT communication services. As we all know today, I mean, there are at least probably 50 clones of WhatsApp that already exist. And if you use WebRTC and the kinds of technologies which allow you to provide real-time voice support for any browser or any mobile application, you can imagine the kind of numbers we are talking. In fact, what is now in the bill's mindset an exceptional thing will in fact be the norm. In fact, you will find literally thousands of services which will meet the criteria of a telecommunications service in the sense of the bill. Now, clearly, that is both a problem as well as it's theoretically a problem, but it's also a huge challenge for implementation or enforcement. So, and that is precisely what we don't want. The other thing is, of course, that most of these services, the so-called communications apps, whether it is anything like WhatsApp or Zoom or even Twitter and all of them are available as URLs. So these are services which are a part of the actual internet. Now, are you going to now just separate websites based on whether they support one or whether they support real-time communications or not? You have a nightmare when it comes to net neutrality issues. So clearly that is not the way to do. So that is my first point relating to definitions and OTT. The second issue is about spectrum. The spectrum, there is no doubt that spectrum is a finite resource. It often has more demand than supply, and therefore auctions make eminent sense. But the truth is, there is, especially with high frequency spectrum, that situation has been changed completely. Now, it is perfectly possible to share spectrum. And that is how, for example, the advanced Wi-Fi services are working. That is how satellite services are working. That's how a whole host of other services are working based on shared spectrum. And by definition, something that can be shared, it really makes no sense either in terms of efficiency or equity to be auctioning something that can be efficiently shared. In fact, you will actually add inefficiencies because now spectrum is going to be allocated exclusively. I'm not bidding for spectrum in auctions to have shared spectrum. So even spectrum that is shareable will actually get exclusively allocated which is clearly not a very smart thing to do. And remember that this is an area where we are already paying the price of an overly auction-focused approach. We do not have any of the advanced Wi-Fi technologies. We don't have Wi-Fi 6E, we don't have wide gate, we don't have any of the satellite communications, despite being a space bar, we don't have any serious satellite broadband and so on and so forth. And I believe that that is a direct consequence of an extremely narrow approach, and sadly added to by the Supreme Court because it was dealing with an entirely different issue. It has clarified later that it does not believe auctions are a constitutional principle, but be that as it may be, it has confused issues, and that is causing a lot of problems, and manifestly it is hurting us and our consumers and our economy. So that is something that we needed to correct quite urgently. And the last point I would make, and I hope I am not overstepping my time, Amrita, I'll take 2 minutes more. Is this whole business of the TRAI pass. These powers that TRAI has, which are relatively limited to recommendations relating to licensing, were extremely hard fought. In fact, those of us who were there at the time recall how difficult it was for the TRAI Act to be amended to allow the TRAI to at least recommend licensing terms and conditions without any obligation on the government to accept them. But the recommendations from the TRAI were mandatory. Disagreement with them by the government was okay, but they still required the government to refer back to the TRAI once more. And if even after that they disagreed, they could go ahead, the government could go ahead and do what it felt like. But it was a huge means of providing a certain regulatory consistency and regulatory scrutiny. And I think by removing this and the TRAI's recommendatory rule, we are actually reducing regulatory scrutiny at a time when we need it most. Because right now, the point that Neha also made about government discretion, etc., this is the time when you want actually regulators to be conducting nuanced and sophisticated analysis of market conditions, technologies, etc. This is not the expertise of governments, DOT, or any other part of the government. This is something that a specialist body should have been doing and is doing, and its peers are doing. Or virtually all the reform that I mentioned relating to spectrum was led by regulators. And in fact, the explanatory memorandum or explanatory note makes a big deal about studying international best practices in detail. Sadly, I think it is quite misleading because none of the countries, except probably Singapore to some extent, follows any of the kind of licensing approaches or the kind of approach to regulators that the bill seems to be advocating. So I do believe that the bill needs some seriously comprehensive review, and we hope it will happen. There's really nothing wrong with having a consolidated single up-to-date act, but sadly, this is not that. Thank you.
Thank you, sir. May I bring in Rajesh now? Rajesh, you represent the interest of the internet service providers, big and small. Could you share what ISPAI is thinking about this bill? Rajesh, would you be able to speak now?
Oh, sorry. Thank you, Amrita, for pitching in the service provider, specifically the internet service provider, because nowadays we are looking that everybody, whether it's they are the telco or anyone, they are now using the data. And dependency on the data is increasing. 1995 and now we are in 2022. Such a vast journey, more than 20 years experience to the government of telecom industry. No doubtly, the government, the department is very positive by bringing in the new act or new bill towards the telecom industry. But somehow the things have not so improved as I have heard Uppal ji, Amit, Mathur and Neha. The same theory of cut, copy, paste. They have taken lot of things from the old bill and pasted in the new bill, as well as they are somehow curtailing the rights of our regulator and the TDSAT, which is very harmful, taking all the responsibility or taking all the things to their hand. And moreover, our Honorable Prime Minister, when he taken the charge in 2014, at that time, he has told more governance, less government. But through this bill, we are not able to find that thing, that more governance and less government. Service providers are thinking very seriously. We are taking it very seriously.
I think, sir, you may
We are
your video.
preparing the
Your voice is
response to be submitted, in which we are going. Okay, I'm just stopping.
Yes, yes.
Okay, now it's fine.
Yes.
Now we are also preparing the response from our side and hope that the government will consider the responses of all the service provider and will not put all the responsibility on the service provider. We have to share the responsibility. Like Amit was saying about the security aspect, KYC aspect. The similar way, we also have the same view that if we want that the thing should progress, so we have to share the responsibility with each other. Like I'm also taking the point of the ROW. No doubtly, the central government has come very positively towards the ROW, but whether the state will agree, whether the local government will agree, this is the biggest question. And this has to be answered because the local department says that till the time we are not getting the share of our revenue, why we will allow you? And they just unnecessarily delay the file. Those
I think.
yeah, the voice is getting muted again and again. There is some technical issue. So these are some issues which we have to look very positively to address the challenges being faced by the service provider, so that actual digital India should be there. Because at one way we are talking of the digital India, and at the other way we are controlling the things in the same way. One thing I will agree that at least in the bill, retrospective word has been removed. So if nothing is coming as a retrospective, then it is
I think we need better
thing
ISPs.
of at least a breathing space to service provider, that they will not be.
Rajesh, we are unfortunately able to hear you. The last part,
Hello.
I think you're in a very bad connectivity place somehow.
Nikhil, are you saying something?
Sir, I was just saying we need better ISPs. You have very bad connectivity.
I can't say. I'm in Hyderabad. and I am on mobile, and my phone is showing 4G. No comments on that. Anyway, the things are coming very positively from the government side. The government should not be taking it as a more and more government and more governance. They should be going with the more governance, less government, and should liberalize the way the people will work positively. I think because I'm not able to, voice are coming drastically cutting.
Right. No, I understand, sir. I think people have understood what you were trying to say. And in case anything is there, you can put it on chat.
Sure.
But thank you so much for joining in from even when you're traveling. So may I now bring in Kazim. Kazim, you represent the Dialogue, which is a think tank. You look at the industry perspectives. You also look at the rights of users, etc. How are you looking at the bill? Any particular thing which you would like to raise?
Thank you, Amrita, for having me. I hope I'm audible. Okay, great. So a lot of issues have already been covered by the panelists, so I don't want to sort of go into repeating certain things, but there are a couple of things which I sort of want to look into. I think first, broadly, I think we need to ask this question, is there a need to regulate the OTT services, right? I think that's a question we need to understand. Is there a market failure? Is there a lack of regulation? Because if you look at the IT Act, the IT rules, which were passed last year, there is sufficient amount of regulation already happening. So do we need to bring in OTT services, internet-based communication services in the form of another regulation? And of course, that will just sort of complicate the process even more. So I think that's a question we need to ask. And I think the government also need to look at when it talks about sort of streamlining the services or streamlining the regulation of services, we are actually sort of making it counterproductive. So that's the first point I wanted to sort of drive. And the second point I just want to sort of focus a little bit is on the substitutability part. And I think some of you may remember that in 2018, TRAI had come up with a consultation paper on regulation of OTTs. And I think at that time as well, there was a lot of discussion happening around whether OTTs are substitutable to the telecom services. We see the same thing happening again, being repeated again with respect to the definition or the very wide ambit of the definition of telecom services, which we've been discussing today. And over here, I think I just sort of want to focus a little bit on the technical differences between the OTT internet-based services and the telecom services, right? And I think, as we all know, the telecom services are basically based on a network application, right? The infrastructure which is set up through spectrum allocation is what the technology which is driving telecom services. OTT platforms, over-the-top platforms, internet-based platforms are basically providing a layer of application above the network which has already been established. So from that perspective, these two are different services, number one. Number two, the communication data through the OTT platforms is delivered in the form of data packets, right? Through the best effort delivery model. And there is no dedicated end-to-end channel established during the form of communication. But when we look at the telecom services, which function atop circuit switched PSTN architecture, they have dedicated channels of communication, which are established between the various devices during the form of communication. So the infrastructure for providing telecom services is established, and the internet-based communication technology is a layer on top of that. It's just an addition on top of that. It does not have its own infrastructure. So you can say that the TSPs can function without OTTs, but the OTTs cannot really function without the TSPs. Right. I think one more point over here is, when we talk about the different type of communication services, we also look at the difference of business models, right? When you look at a basic SMS service, the way it functions, it's very different from a communication platform. The business model, the architecture, the way they sort of perform their the functions, etc., is very different. So should we bring these two different technologies together? Should we regulate these technologies together? Are they really substitutable? In my opinion, no. And that's something which we had submitted in our presentation, in our representation 4 years ago. And that's something which I think we are again going back to this debate once again. Another point over here is the fact that most of the, the substitutability discussion, and when we talk about competition, are basically focused on product and services, right? So you can have similar products, you can have similar services, and there is a debate, okay, whether you can substitute one product or for another product or one service for another service. In this case, the technological architecture is totally different, right? So the whole question of substitutability sort of falls through the cracks when it comes to OTTs versus telecommunication services. Another point which I sort of want to focus a little bit is on the impact of this draft bill on end-to-end encryption service providers specifically. And a lot of us, today depend on end-to-end encryption platforms for communication. These are privacy respecting platforms. And when we talk about the bill, it basically talks about intercepting intercepting these platforms. Basically, all the communication which now happens will be intercepted, and you have to provide that data. And this is going to undermine end-to-end encryption very much. And this is a step further from traceability, which we saw last year in IT rules 2021, when the government introduced traceability under 4.2 of the rules. Over there, the government was looking at tracing the originator of content. It wasn't talking about accessing content or being able to intercept content. But in the draft bill right now, it has gone a step further, where the bill is asking agencies to intercept communication even through end-to-end encrypted platforms, which is actually going to undermine and weaken encryption even more than what it did previously. When it comes to traceability, right? So this is a step further when we talk about the impact it will have on E2E service providers, the impact it will have on the privacy of all the people who use these services, and also the impact in general when it comes to data, because a lot of this data which has to be intercepted may need to be collected, stored for a time period, which means that the platforms will have to collect this information, find a way to do that technologically, and that also leaves the security and privacy of users vulnerable, right? Because tomorrow, what happens if there's a breach at the back end with all this data collected and stored? Who will be responsible then? What happens there when it comes to privacy of users? I also sort of want to go and discuss a little bit about, generally interception as well, and the lack of a surveillance law right now, the lack of a data protection law right now. And what we're trying to do is, through some of these measures, through the telecom bill, what we're doing is basically mandating collection and storage of more and more personal data. This is especially critical when we do not have a data protection law in place. Hopefully we will next year. And also the fact that we are widening the interception powers, and we don't have any checks and balances, pretty much no safeguards at all within the present telecom bill when it comes to checks and balances for agencies to collect data under national security purposes or whatever. And of course, national security, etc., is also not defined within the bill. So that's also something which we want to propose and say, look, if you want to intercept, if you want to collect data, it has to be done through checks and balances. There has to be certain safeguards. In general, I think there is a demand and there is a need, and this is a good time to talk about surveillance reforms, the need for judicial oversight, the need for parliamentary oversight. We've seen that it happened in other countries, in UK, US, etc. That's something which we hope can be delivered in India. In the absence of some of these safeguards, in the absence of some of the data protection laws in place, is it a right time to sort of come up with a law which mandates greater collection of data and greater access to data without these safeguards? I think that's a question we all have to ask ourselves. And finally, I just sort of also want to talk a little bit about the impact it may have on the startup ecosystem. And we've seen in the last couple of years, let's say if I'm a startup trying to come up with a communication platform, I have to now seek licensing within the telecom bill. I have to be regulated within the IT rules, within the IT Act. Then I have to report my breaches within 6 hours to certain. And I also have to, sort of within this entire process, There is no data protection law in place. So as a business, does it impact businesses? This is a question which we all need to understand, we all need to ask and figure out what impact it will have on the industry and on the new internet economy, which is going to develop and be delivered. And with the advent of 5G, and definitely a lot of new startups will emerge. But if you're placing so many requirements and regulatory requirements and overlapping regulatory requirements on startups, would that mean that India as an investor, India as a climate or as a place to invest is re-looked at by investors? I think that's something which we also have to consider.
Right. Thank you, Kazim, for this. I'll bring in Nikhil at the end. Nikhil, you wear multiple hats. One is you have your own, you run MediaNama, which is also, kind of media service, but you also wear the civil rights hat, So I'd like to hear from you on this, your perspectives on this bill. And also there was a request from someone, is there any impact on the broadcasters in case you can hire, if you feel there is something, if you could also raise that. Thanks. Over to you.
Thanks, Amrita. Sorry, I've been listening to everything quite intently, and I have points of agreement and points of disagreement. Firstly, I don't want to give my Aadhaar or my driving license to Facebook for using WhatsApp, right? If you can't have a situation where you're forcing people to part with their KYC document, already you're forcing people to do it for telecom. And the internet is not a telecom service, it's the internet, as in a telecom operator service. So I would say, number one, from a privacy perspective, at one level, you don't want WhatsApp and Facebook sharing data. And now you're saying, give your ID to WhatsApp to be able to do messaging and whatever. I think that's completely ridiculous and it's hypocritical. And this just plays into the surveillance needs of this government, that they want to access messaging services. This is a mechanism for validating the IT rules, which already try and break into an encryption. They're just bringing that entire interception regime to messaging. But like I said, the internet is not a telecom service, as in not a telecom operator service. It is the telecom operators provide access. So if this bill had to improve on the current regime that we had, we would separate content from carriage and access, and let there be an access bill where you're regulating telecom operators and reducing the regulatory burden on them. This whole thing about convergence and whatever the telecom operators have been calling convergence for the last 20 years, that sort of should have died with the death of the convergence bill some 15 odd years ago. So can we just get this antiquated thinking, just take it and throw it out the window and stick to what works, which is you regulate the internet, although I don't want too much regulation for the internet, you regulate the internet as the internet. If you look at the definition, and maybe I'm looking at this definition differently from everybody else, but it's an all-encompassing definition because it doesn't just include internet communication services. It seems to include everything from, it'll include e-commerce, it'll include cloud, it includes all internet communications. Everything on the internet is communication. If you're buying something on e-commerce, you're effectively communicating an intent to buy. If you're making a payment, UPI is a transfer protocol, right? So by the definition, it seems to basically mean that you're trying to bring a licensing framework to the internet. So you may not start with that, but you open the door for that. Going forward, you are also then saying you need to be able to track all activity. So therefore, that throws encryption out the window for everything that happens on the internet. So I was comparing with this view of the definition, because remember, all those services are also in brackets. It's saying including so and so. I don't know, and maybe Neha can correct me about this, but it doesn't just that doesn't just limit it to what it includes, and even those parameters which are included, like broadcasting, electronic mail, voicemail, voice, video, data, communications. data communication services, everything is data communication, internet and broadband services, internet-based communication services, interpersonal communication services, machine-to-machine communication services. This basically means you're trying to bring everything under a licensing framework, which is utterly ridiculous. And that's what I said. The approach we need to take is separation of content from carriage, and junk this idea of convergence altogether. Because there's access services and there are internet services. You're only providing us an access to the internet as a telecom operator. If you're providing us communication services, you have to compete with every other communication service, because otherwise there's no difference between this and the TRI OTT consultation paper in 2015, which talked about licensing Uber and Ola and e-commerce and all of that. So this is just bringing licensing back to the entire internet. And on the national security perspective, you don't, and I think there have been enough, there's even some talk about this in the Supreme Court as well, about social media monitoring. And I remember there are few BJP politicians have gone out and talked about linking Aadhaar to social media so that you only have validated people online. That means that no one, how will we communicate with folks who are not validated, right? Or who have not given their IDs? But also it just creates a complete privacy and security nightmare. So you don't improve national security by reducing security for everyone and making them more vulnerable. There should be less data collection and not more. The minister, when he did this press conference, talked about the need to protect the consumers of the internet. And he said that KYC is necessary to address issues of spam. I don't know, but I get more spam on telecom than I do anywhere else. And KYC hasn't helped the telecom operators reduce spam. In fact, telecom operators are the biggest proponents of spam. They've historically benefited financially from enabling spam on their networks, because that's what their network utilization is based on. They sell by TPC, I think, or whatever, TPMs or transactions, transmissions per million or something. I'd done a story on this in like 2012 or something. They basically bought bulk messaging services, and they've worked hard at the TRI to prevent accountability for the spam that they are enabling, so that they don't necessarily get held accountable for it. So you keep passing the buck for spam on to consumers instead of holding telecom operators accountable for not acting on spammers on their networks and scammers on their networks. Like if their KYC is not working, you want to bring the same KYC mechanism to online services which have actually better fraud detection and prevention mechanisms. Why is it that us as consumers have to pay for the lack of proper security practices and grievance redressal systems at UPI? Let UPI deal with it, instead of trying to do KYC for messaging services. I noticed that there's Steve Song attending this. Hi, Steve. It's been in 2015 or 16, I was judging the Mozilla Open Internet Challenge related to net neutrality, or equal rating challenge, sorry. And Steve had presented something about, if I remember, TV white space spectrum and enabling broadband at a distance. Why is it that from a spectrum perspective, we always talk about more licensing and more revenue generation for the government, when there are parts of spectrum which can actually be opened and enable community broadband networks and community Wi-Fi networks, which will link to ISPs and telcos on the other side. But not everything in spectrum needs to be monetized. Spectrum is a scarce resource, yes, but the telcos are just trying to prevent utilization of useful spectrum. I mean, if they had their way, Wi-Fi would be licensed as well, because they would want to move everyone to telecom, to their own network, so they can monetize it. But I don't see why we should always, like, by law, say that auction is the only mechanism for allocation of spectrum, when there is the basic objective of spectrum allocation should be public interest. And if you can increase public interest by giving spectrum for free, why not? Just getting the government money to balance its fiscal deficit is not necessarily the best mechanism for improving public, for serving public interest. I had taken down other points as well. Yeah, one of the things is that this paper that's come out is based on DOT's, is supposed to be a follow-up to the consultation that DOT did a few months ago. And I'd like to see more transparency from DOT. Why haven't, like MeitY does sometimes, or the TRA always does, why don't we see submissions from everyone to the DOT being made public? That is the proper procedure of public consultations. So I want to see what different telecom operators said in their submissions, because that helps us understand what the motivations are. Because right now, looking at this bill, it looks like it's been written by telecom operators for telecom operators. And I don't see how this is going to be of any benefit to consumers or internet users or digital or startups on the internet. This, like I said, is very similar to the first horrible TRA consultation paper in 2015, and basically throws all the good work that the TRAI did with the 3 consultations that follows out the window. From a broadcast perspective, very clearly, it looks like online streaming services will also have to buy a license. I know Kazim addressed the points on same service, same rules. I went back and looked at Save the Internet submission, which quite a bit of it I had written in 2015 to this argument of same service, same rules. And I remember writing there in particular that, we have, if you want to apply same service, same rules, then there's a mobile VAS service called mobile radio. Telecom operators should buy a mobile radio, like a FM radio license to run music streaming on VAS like they do. There is another license. They also allow payments for services using on VAS using the prepaid balance. So why haven't they bought a payment gateway license from the RBI? Look, there is no direct correlation between what the telecom operators provide and what online services provide. You look at the evolution of messaging on the internet. You look at, and it's beautiful the way WeChat has evolved from starting as a messaging service to, you can book cabs directly through it. You can you can do shopping directly through it. Evolution has happened on top of messaging on the internet, and every messaging app tries to become a super app, and every super app, let's look at Paytm, right, tries to become a messaging app, because messaging brings with it the highest daily active users. WhatsApp won because it had the highest daily active users, and now it's evolving more into telecom related services, which are riding again on top of telecom. Right. So let's just be very, very clear. The internet is not a telecom operator service. Access to the internet is. If telecom operators are using VoIP, that they're providing on top of it. There's no direct substitution. Messaging is used for customer service apps. Fresh, which is India's only SaaS company that's listed on NASDAQ, I think. Has messaging. Zoho has messaging. There's email that's a part of this. It's ridiculous the way they're thinking about licensing all messaging, and not just messaging. This will impact cloud as well. Look at the definition of telecom. All cloud service providers will have to buy a license to operate in India. And there you meet your goals of data localization, right? Because then telecom operators have to localize their data in India. So this is going back to 2001 or something like that, the way this bill is constructed. It is as bad as the Telegraph Act as far as the internet is concerned. I don't see it as an improvement, and I think it should be scrapped the way it is. And I would encourage everyone to challenge what these guys are saying with this bill. It's complete nonsense what we're saying with this bill.
Thanks, Nikhil. And just so that you know, Nikhil is organizing a discussion on the same topic on 18th. It's a face-to-face, event, but obviously you have to register first, and seats are limited because of, everything. It's not an online event. So in case you're interested, do go in. And Nikhil, if you could drop in the link here for people to register, that would be good. Ahita, I would like to ask you, while there were certain questions raised, many of them have been responded on the chat. Is there any particular question which was not answered? If you can raise it. And anyone who wants to comment, question, you can raise your hand. I know, Sanjana, you wanted to speak. After Ahita reads the questions, you can speak briefly.
Thank you, Amrita. Thank you very much, panelists. Most of the questions have been answered in the chat by Neha and Uttara, but there are this question by Anurag and Steve. They're quite linked, so I'll just read them out together. The question is directed to Mr. Amit Mathur. So the question is, on going only via auction way, what do you think about higher bands like millimeter wave, where we have practically infinite spectrum? Thus, if scarcity factor is not there, would you still feel auction is the only way? And adding to this question, what is Jio's perspective on how spectrum might be made available for private LTE or 5G networks, such as been enacted in the UK, France, Germany, New Zealand, and the States? I'll copy the question and paste it again for reference. Mr. Amit, would you like to take it up?
Yeah, okay. There are two parts to it. When we look at spectrum, I had also talked about, auction is the way to go forward. Even if you're talking about the higher bands, the spectrum availability could be much higher, but then the demand of the requirement is also going to be much higher. And if you're talking about higher speeds, higher bandwidth throughput to be provided to the end customer, the requirements are going to be much higher. But our view is very clear that auction is the way to go for it when we are talking about any commercial usage of that. So that's one part of it. And the second part, I would not like to comment, because that's something which is still being worked out, how the whole process is going to happen. DOT has called for some inputs from the private players who want to utilize it for private networks. So that issue is still open, so we'd not like to comment right now on this.
Thank you, Amit. Ahita, there's a question by Samrid, right?
Samriddhi, yeah, fellow with Youth IGF. I'll just read it out. The question is for Nikhil. Since you specified that a lot of stakeholders are being put at a disadvantage as a result of this bill, is the bill also an attempt to establish an oligopoly or somewhat curb innovation completely?
An oligopoly of telecom operators, maybe. That's what they tried back in 2015. And I was there on August 8th, 2014 at the at that fateful conference that the TRAI held, where telcos, just like they're doing in Europe now, are asking for online services to pay them fees to be able to provision access to those services, and that's what they tried subsequently. I remember, so telecom operators historically have always tried to take control of the internet. They go crying to the regulator and DOT at one level, saying that, oh, we don't have enough money, we're losing money, we don't have enough, you're conducting auctions, taking our money, but look at these billion-dollar companies that are being set up on the internet. For me, the turning point at that point, I think, for the telcos was when WhatsApp was bought for $19 billion by Facebook. And Airtel's valuation was lower than that, right? And that's when Gopal Vittal started pushing for it. And if you go to the earnings conference calls, they keep telling their investors that VoIP is not a problem. We actually cited some of this in our submission in 2016 to the TRAI, 15 to the TRAI, 16. I just took investor calls and quoted them. The only oligopoly that we're looking at is telecom operator oligopoly. And they've always wanted to make money off online services. That's going to be detrimental to the startup ecosystem. And I don't know how much Ashwini Vaishnav understands the mess that this is going to create. Sorry, what is the second part of your question?
Yeah, I was asking whether it will completely, sort of remove innovation, because now, since, as you said,
It does. No, that's actually a great point. It does remove innovation, right? Because if you look at the internet, right, everything is about bundling or unbundling, and that's where innovation happens. So you take access to transportation services and bundle messaging and payments into that, and you get an Uber. You take messaging services, plonk it on an e-commerce website as a pop-up, and you get customer support taking place on live chat on that website. So the internet's always about bundling and unbundling, and many companies are shape-shifting. Like one of India's most successful startups is a company called InMobi. It started as a service, as a mobile search service called M-Codes. And I knew Naveen then, and we actually did a conversation with him at 2 years of InMobi. And he talked about how they changed the business model and then started being an online advertising business. And they became the third largest ad network in the world, mobile ad network in the world. And now what's successful them is a product called Glance, which is on your home screens on apps, right? So businesses have to keep changing the way they function on the internet because the market changes. Product market fit actually shifts, and startups are constantly testing that product market fit because they have to be versatile, and they have to, and to in order to change according to consumer demands, which is where they require a substantial amount of funding, and they're in an environment of infinite competition. Licensing actually helps some of them because licensing always kills off new competition. So you might find that some startups will actually support licensing like they do in digital payments, for example, because it helps the incumbents. Where it harms the ecosystem is competition, because if I'm WeChat, for example, right? If I'm a WeChat kind of a service in India and I run messaging, I have to buy a license for messaging. I want to incorporate payments into it, I have to buy a license for payments. I want to do e-commerce on the platform, I'll have to buy a license for e-commerce. Every time there are multiple regulatory burdens that come for everything that I do, whereas all I'm trying to do is find a product market fit. So you don't really survive in that kind of an environment unless you raise substantial more funding. And therefore funding also dries up because the cost of innovation increases to that great an extent. So like I said, this right now, as far as I understand, the startup community doesn't know that this bill even exists. And this is going to be disastrous for them because the language is quite vague in that sense, right? Everyone's interpreted the way telecommunication services are defined differently from what I have. Because I'm seeing this as an all-encompassing definition. Everyone is looking at it from the way the minister talked about it in his press conference or the explanatory memorandum does. But the letter is, the text of that says it includes everything, because everything on the internet is a communication service. So
Thanks.
This is going to be awful.
I'll just take the other questions.
Sorry.
Yeah, Sanjana, you wanted to make some quick points?
Yeah, good evening, everyone. I just wanted to say thank you for the discussion as it has been so far. It was such an informative way to spend an hour and a half. What I wanted to point out very quickly was that even assuming like implementation best cases for some of the things that we pointed out as problems over the course of this discussion, I don't know that we will successfully achieve the goals that the government has also set out, right? Just purely like our concerns about things like encryption on one side, from like a pure law perspective of whether or not privacy is something that ought to be enshrined separately and treated as sort of a priority. The manner in which they choose to dilute it doesn't necessarily mean that they're going to meet their end results. Like this presumes that internet usage and the access to KYC facilities or people who have access to documentation that's required for KYC have grown sort of together. When in fact it hasn't, right? Market penetration on like the usage of devices and things like that is far greater. And like there's far more knowledge of like what, for example, a WhatsApp is or a Snapchat is or like an Instagram is. And through that, a lot of people will then have to realize what their KYC requirements are. So while there are certain systems built for KYC and things like that with banking and things that are intuitive connections that a lot of people make, a lot of users might not be able to fulfill the need that the bill has, which is to say that then the secondary concern of whether encryption will dilute it, etc., comes into place. Even assuming that there exists a perfect rationale for some of these things within the bill itself, implementation might not necessarily get us the end results that we want. And because the definition of telecommunication services is so wide, and because a lot of these platforms hinge on things like encryption being their sell to like a slightly more informed consumer who wants their data to be treated or protected in a certain manner, will effectively be tamping down innovation and tamping down the kind of money there is to be made for these people and for new entrants into this market without necessarily getting that much of a net gain. In that these TSPs might have more of a secure market share or less competition because a lot more money, not less competition so much as a lot more money going into that system, and they don't feel like they're providing a service for a lot less than they should be. It may not necessarily have the impact that the telecom bill chose to achieve.
Thanks a lot, Sanjana. Shashank, you had a question. Do you want to speak it out loud?
Yeah, so hi, good evening. Thank you for the session. So this question is directed to any panelist that wants to answer this. So my question was, when it comes to surveillance, the bill enumerates public safety and public emergency safeguard for the sake of it. But also there is a section 69 of the IT Act, which allows the government to intercept any information that is transferred from computer source. So is this current framework or the safety framework the bill intends to incorporate, is this sufficient to actually achieve a purpose that the minister said in the conference?
Okay, while the speakers think about it, anyone else has a question or comment?
I have a quick comment.
Okay, I'll come to you, Nikhil. As speakers, you will be making comments, but I'm just trying to take in if anyone else has any questions, comments. Else, we will go to the speakers for their last round of comments and to respond to the last question. I guess no. So Nikhil, you will have to wait. I will come to you, but first I will go to Uttara because I think Neha had to drop off. Uttara, over to you. Your last comments, or if you want to respond to any questions.
Oh, thank you, Amrita. I think to Shashank's question, short answer, yeah, it's absolutely an overlapping requirement, right? There is already an existing interception and surveillance provision within the IT Act, and this is I think it's section 25 in this current bill. It's additional. It has no procedural safeguards. Even the MeitY bill, the IT Act does not have that many procedural safeguards, but it exists somewhat in paper, right? So section 25 does not have any procedural safeguards. So to that extent, it should be completely reconsidered, or at the very least, it should be some sort of safeguard introduced in the bill. That's the sense I have. In terms of last comments, yeah, I think all the panelists succinctly summarized this. To my mind, and I said this when I was speaking as well, is that I don't know that DOT has fully internalized the extent to which this particular bill is going to stifle innovation. Nikhil made this point as well. Every single company would fall on the infrastructure layer, could potentially fall under the definition of telecommunication services or internet communication services. I just find it really, it strikes me as odd that on the one hand, we have so much pride about our startups and our unicorns and how well they are doing. And there is this big legacy goal of turning India into $1 trillion digital economy. But on the other hand, the brass tacks of many laws, right? I mean, this particular bill is one example, but several others as well don't seem to align with our objective. This is yet another instance. It's a bit of a pattern, I think, that we're seeing. And I think it's important for us to come together and sort of make this plea that, hey, listen, to the extent that the goal of the government is to enable innovation and keep people safe, several laws, including this particular law, are not actually serving that purpose and are in fact going to create a host of unintended consequences, right? So that just seems to be the main takeaway for me from this particular bill, and I'll stop there and I'll speak as well. Thank you.
Right, thank you. Amit, would you like to share your last thoughts?
Yeah, I think just wanted to react to what Shashank had asked for. Today, the telecom arena, yes, there are certain interception rules which are defined, which has the checks and balances. They came again out of the judgment from Supreme Court, where they wanted a very specific framework to be formed for it. So that's one area where, if you look at it, the bill and how are the rules going to be formulated under the bill, under various sections which we are talking about, that is also to be seen, because that is going to make a lot of difference into how the whole thing is getting interpreted and how is it going to get implemented. So that's something which all of us will have to wait and see, and then when the bill gets passed, and then the rules start getting formulated based on that. That's one area which I had. The other, just one comment which I missed out, I think I'd just like to share with everybody. Today, the bill gives the kind of power to the government, or I would say the department, is much, much higher than what is available today in the current Telegraph Act. He can go ahead and waive off any charges. Today, I may go and commit and say that, look, I'll pay you, say, 10,000 crores for the spectrum. And tomorrow, if I go and say that, look, no, I am not able to pay, the guy can decide and say that, okay, I'll waive off everything. Now, that's kind of a discriminatory power which is going to come in, is pretty scary for everybody, as for the whole industry. So that's something which we feel that needs to be looked at it, the checks and balances. That is why we talked about the TRA Act and the TDSAT, which bring in the checks and balances to all these actions, is very, very critical to the whole thing to work well. These are my last comments.
Right, thank you. Before I go to Dr. Uppal, may I bring in Akshi? Akshi, your last comments.
Thanks, Amrita. I think mostly everybody has raised that point here, and it's, sort of everybody has already raised that point that we'll have to see what sort of checks and balances are brought in, what sort of safeguards are there, the overarching definition of telecom services. I think, and this is coming specifically from, my point of view as a lawyer, I think there's a lot in this right now that we can't comment on, because a lot of these provisions, and I think I'd said this earlier also, a lot of these provisions are depend on, standards that are to be prescribed, or something, some condition, some term that will be prescribed. So a lot of this will actually depend on how those terms and conditions, in fact, are first prescribed, for us to be actually clearly able to see what's going to be the harm or what's going to be the advantage and how's the government looking at implementing it. But otherwise, yes, I would agree with a lot of concerns that most of these panelists here and people in the comments have already raised, that there are concerns maybe around, human rights, or maybe there are concerns around how is it going to be implemented, the very, very overarching definition of telecom services itself as well.
Right, thank you. Dr. Uppal, your last words.
Yes, pretty much everything that I would normally have said has already been said, so I won't go around saying it all over again. But let me just say this, that the bill claims, and the explanatory note says, that the new legislation is intended to be future ready. It is meant to be, it's essentially supposed to be future ready. And this, I think, given what we have heard, I think if anything, it is setting us back by many years. And I think a key part of anything being future ready would have been to have specialist regulators in particular take decisions that require nuance and sophistication. And it cannot be anybody's idea of making anything future ready if a bill seeks to reduce scrutiny, reduce discretion of competent and independent regulators. So I do believe that it's a very serious setback. I also believe that the whole approach to both OTTs as well as spectrum is actually retrograde, and it's something that is not only unenforceable, but will actually hurt the ecosystem. It's already hurting consumers because there are several services which currently are available elsewhere, which we are not able to access because of the restrictions of our licensing regime. And what we're doing is actually strengthening it. So we are actually increasing state control rather than decreasing it and ceding it to regulators, as is the best practice across the world. And sadly, the bill claims that it follows greater world best practices. I think that is a claim which simply cannot be sustained. Thank you.
Thank you so much, sir. Kazim, over to you. Your last words.
So not much to add. Amrita, thanks a lot for this discussion. Really interesting and insightful. Just a few recommendations and hopefully suggestions which can be looked into. One, I think we need to keep internet-based services, OTT, communication services, etc., outside the ambit of this bill. I think that's number one, which I sort of want to focus on. Second is, I think this bill was an opportunity to sort of reform the old Indian Telegraph Act. And what we've done is we've gone back to where we started. We don't have enough safeguards, privacy respecting safeguards when it comes to interception. I hope that those safeguards could be included when it comes to interception, when it comes to government access to data, when it comes to national security, etc. There should be greater, narrower definitions when it comes to what kind of data can be accessed under what circumstances. I think those sort of safeguards have to be built into the law, to the bill. So hopefully the bill could be revised to do that. And I think also the fact that finally, I think when we look at the autonomy of TRAI, I think we need to sort of bring that back. So hopefully that could also be looked into. So I think these are the sort of broad three recommendations. But I do feel that this bill should wait before the data protection bill. I do feel that the privacy law should first come into force because if this is how it's going to go, then definitely this is violating the right to privacy. Let's wait for the privacy law. Let's wait for the data protection law to be first passed. I think we need to revisit all these aspects of the telecom bill, maybe redraft it, and then sort of introduce it back to consultation process.
Right, thank you. And Nikhil, I know you have been patiently waiting for the last words, so over to you.
Yeah, I just wanted to add to what Kazim said about the autonomy of the TRAI. It looks like no good deed goes unpunished. You had a TRAI that actually reformed under R.S. Sharma and was more in public interest and more focused on consumer interest, and as compared to previous TRAIs that were largely focused on telecom operator interest. So looks like this is the DOT taking the power back from the TRAI, and the internet will suffer for it. And we've seen the telco shenanigans from 2015 onwards and what they were trying to do. We covered those submissions on MediaNama, and you can still read them there. And I remember Jio asking for registration of online services. So, we really want a more open internet. We want we want less control of the internet, but broad policy direction is towards more control. And we're seeing that across domains. On the surveillance question that was raised, just remember how bad it is when you use a regular telecom service, where if you're using a telecom call, there is absolutely nothing preventing the government from surveilling it, recording it. And there is a centralized monitoring system which exists across telecom operators that is able to surveil all your messages as well as all your calls. These orders are passed through a government via a secretary, I've forgotten what level, and they're reviewed by a review committee that I think ends up reviewing some 300 orders a day. That was the last disclosed number. So the scale at which mass surveillance takes place on regular telecom services, what you're looking at is that being brought to online services once surveillance gets impacted. And I was at the TRAI OTT consultation in Delhi, and Amrita, you were there as well. If you remember, there were folks from the armed forces sitting there saying that they want access to calls and messages on WhatsApp. This level of while at one level we're asking for surveillance reform in line with the Puttaswamy judgment. What the government is doing is bringing unregulated or rather unrestricted surveillance mechanisms which they currently have to messaging services. And this is also a means to justify the illegal IT rules that we have, which enable the breaking of end-to-end encryption or enforce the breaking of end-to-end encryption, which is a case that's already in court. So we need to be very I would suggest that everyone who's on this call, please participate in the consultation. Please submit your responses. Please push for our rights as citizens of this country. Please push for reform and please push back against the regressive, provisions that are in this bill. I think that's it's the least that we can do. In some cases, it's all that we can do right now.
Thank you, Nikhil, and thank you to all the speakers and all the participants who were there for nearly 120 minutes, and sharing. What we would be doing next from our end is we would be making a report and circulating to everyone, and also the recording, so that, and encouraging people basically to make submissions. The Youth IGF, as I mentioned, the group would be making their submissions, which is a good thing because the young people actually need to, participate and voice their concerns. It's their future we are talking about. Not only our present. So, and then obviously make your submissions. In case anyone needs any help, most of the, Kazim or Nikhil or even Dr. Uppal has various papers or points which they have, I can always ask them to share it in the mailing lists, etc., so that if it helps you in making your submissions, nothing like it. Obviously, you have your point of view, but if these their perspectives or if others also help you in making submissions, nothing like it. So thank you, everyone, and thank you for being here. And please make your submissions.
Recording stopped.
Thanks, Amrita.
Yeah, thanks, Amrita. Thanks, everyone.
Thanks, everyone.
Thank you. Thanks, Amrita.
Subhrajit, you have to stop the recording.
Okay.